As soon as mom received our motion, she told Evie that my client was trying to take Evie away from her. It's my understanding, based on review of some text messages, mom's having emotional control regulation issues where she's crying all the time. She's having anger outbursts.
Because child support went from $0 because they had reserved it to over 1,100. They had them making 52,000 a year, which my clients never made.
He wants to have parenting time. We'd like to get some temporary parenting time established today. I believe any bonding that Mr. Carestas can have with this child is going to be to the benefit of the child.
Having had no contact with the child other than the 1 5-minute or less phone call, I would ask that the court will suspend his parenting time completely at this time. I think until we can determine whether the dad is going to be in this child's life, it would just be better to continue his routine that he's had for the most of this year.
Miss Owner hasn't allowed me to see my child, so
I literally have no more money. I've spent all my money trying to do the best I can for my daughter and keep her away from people she doesn't want to be around.
Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion to modify custody, parenting time support, and for psychological assessment. Ms. Reed.
Thank you, Your Honor. The most recent order regarding custody and parenting time is the parties' judgment of divorce, which was entered in October of 2018. And that awards the parties joint legal custody, joint physical custody, and alternating weeks parenting time. For over a year now, the children have primarily resided with my client. The party's son has only had maybe 4 overnights with mom in that year. The party's daughter was seeing mom alternating weekends during the summer. In May of this year, mom had filed a motion to modify parenting time to award herself some weekend parenting time. Then she did not appear at the referee hearing, so that matter was dismissed. It's my understanding, based on review of some text messages, mom's having emotional control regulation issues where she's crying all the time. She's having anger outbursts. One of those led to the child texting my client, pleading to be picked up because mom wouldn't stop screaming. So we're requesting that psychological assessment with Dr. Haugen or someone he recommends. We're also requesting that parenting time be modified with mom to alternating weekends year-round, as I believe the parties have discussed this at length, because it kind of works with mom's work schedule at the moment. It's my understanding that she's working quite a bit. And we're also requesting child support be modified according to that schedule. There is also a provision in the party's judgment of divorce that provides that only plaintiff would be picking up medications from the pharmacy. And it's my understanding that's because the parties were trying to go to the pharmacy at the same time, not really communicating with each other with who was picking up the meds. But that hasn't been followed in years. So we're requesting that provision be stricken, as well as there's been some concerning communication between mom and the daughter, Evie, and that as soon as mom received our motion, she told Evie that my client was trying to take Evie away from her, which is not appropriate, which really upset the child. So that kind of communication should not be occurring.
Okay, thank you. Ms. Owen, what's your response?
Well, on May 8th, I filed a motion requesting that I have Evie every weekend.
Okay, ma'am, we're not going to address your motion. It's done. So we're addressing this motion.
I received this motion in the mail on Thursday evening. I hadn't had time to give you or the courts anything. I didn't get to get my attorney. I got nothing because I received it on Thursday.
Okay, are you going to have an attorney represent you?
That was the plan, yes.
Okay. All we do is we'll put this matter, we'll adjourn it 1 week to allow the plaintiff to have representation. So, Ms. Owen, you're going to have to get to your attorney and get them to file a response or to appear next week at the same time at 9:30 a.m.
Okay, Monday at 9:30?
Yes.
Okay.
Okay.
I have a question about tomorrow. I have a hearing with Stephen regarding child support. What goes on with that?
That's assume that's before the referee. I'm not going to address that. We're simply putting this motion over for 1 week to accommodate you.
Okay.
Okay.
Thank
you. You're free
Yep.
to go. Have a good day.
Thank you, sir.
Court will note the appearance of miscapture on behalf of the plaintiff, Mr. Bailey on behalf of defendant. This matter is before the court on the plaintiff's motion to establish paternity for custody, support, parenting time. In this particular matter, I'll ask, have the parties undergone any paternity testing in this matter, miscapture, that you're aware of?
Not yet, nope.
Okay. Well, the court would order paternity testing in this particular matter. Ms. Capture, you can proceed with the rest of your motion.
Thank you, Your Honor. It is agreeable to the parties that paternity testing occur. We're requesting that occur within the next 7 days, and be split cost-wise between the parties. The reason we're hoping that it can occur very quickly is because defendant is going to be moving out of the state within basically the month. And so we want to get it done pretty quickly so that we can get in front of the judge again.
Let me ask Mr. Bailey. Mr. Bailey, you have any problem with doing that within the next 7
No,
days? Having the parties divide the cost?
No, we do not have a problem with that, Your Honor. We'd like to get this done as quick as possible so that he can have some parenting time with his child before he goes into the Army.
Okay. Well, we'll include that in the order. Go ahead with the rest of your motion, Ms. Capture.
Thank you, Your Honor. As my motion stated, minor child is very young infant and has some serious medical issues. Plaintiff has been caring for the minor child since birth. Defendant has not had any parenting time, and paternity is not established at this time. And we are hoping that we can get a temporary order of sole legal custody, primary physical custody. And if defendant does want parenting time prior to paternity being established, we would be agreeable to supervise parenting time with plaintiff being the supervisor, because plaintiff understands how to care for the medical needs of the minor child. Again, very sensitive medical needs, as they were described in the motion. And so there's a lot of attention that needs to be paid to the minor child, especially when cleaning diapers. Furthermore, Your Honor, we would ask that child support be calculated pursuant to the Michigan Child Support Formula. Thank you.
Okay, thank you. Mr. Bailey?
Thank you, Your Honor. Yes, my client is on board for getting the DNA test done as soon as possible. He wants to see his child. He has about 4.5 weeks. He's leaving on October 15th for basic training. So he wants to have parenting time. We'd like to get some temporary parenting time established today. It can be supervised by mom. However, once the paternity test is done, I'd hope to work with Ms. Capture to determine a different schedule. But again, today, as we don't have the DNA test done, I don't know if either party would object to some supervised parenting time going on immediately. I believe Ms. Capture and I can work on the child support guidelines to determine child support. However, my client, the defendant, will have 4 different levels of pay in the next year. And that's one of the only, I think, real complication to determining child support is how much is it going to be when.
Okay.
And dealing with the Army. The Army's not hard to deal with, but I don't know how they're going to feel about 3 different income withholding years.
Yeah.
So,
Well, what we can do is there is a way to put that in place and have it a graduated amount.
yes.
So we'll leave that up to the 2 attorneys to work out, but obviously we've done it in the past and it's able to work out. Like you say, I don't have the confidence you do in the Army. I've had to deal with them in the past.
Well, I didn't say I had confidence, Your Honor.
Oh, okay.
I just said that I know they'll do it at some point.
Okay.
So, yes.
Well, what the court's going to do is the court will grant the plaintiff custody in this matter, support pursuant to the guidelines. The parties can work that out as to what the guideline amount is. The court would allow supervised parenting time in this matter. Ms. Capture, what are your thoughts on the amount of time in the next 4.5 weeks?
Oh, Your Honor, I think at this point, if we do supervised pursuant to the Calhoun County infant parenting time schedule, I think that allots for a couple hours twice a week.
That's what the court, I have written down. The court was going to order that the parties would obviously cooperate with regard to that, but that the defendant would have no less than 2 2 hour supervised parenting time with the plaintiff. If the parties can work out more, then that's fine, but otherwise it'll be at the 2 hours segment.
Your Honor, may I address that before you
Yes,
move on?
go ahead.
Again, this Mr. Crestus is going to be leaving in about 4.5 weeks. That is his block of time to see this child. This child, I believe, is 6 weeks old now. Having 3 kids and 6 grandkids, a 6-week-old is just not that cognizant of what's going on. But I believe any bonding that Mr. Crestus can have with this child is going to be to the benefit of the child. We were going to my client asked me to propose 4 times a week at an hour and a half. It would be supervised until the DNA test is done. Then it could be at the plaintiff's home, but he would prefer for her not to be sitting in the room watching him. If there is a diaper change or some medical emergency, she's in the next room to deal with it. And that would be our request for parenting time.
Okay. Ms. Capture, what are your thoughts on 4 1.5 hour section?
Your Honor, I think that's very hectic of a schedule, given that my client's eventually going to have to go back to work. I'm sure Mr. Karatis is currently working. I believe right now, 2 hours pursuant to the Calhoun County infancy schedule with plaintiff supervised is sufficient. That gives him 4 hours. And if we can work out between the parties some additional time for defendant, then great. Otherwise, I think the minimum should just be the infancy schedule supervised with plaintiff.
Well, what the court will do is, as I stated, the court will implement a 2 hours twice a week supervised by the plaintiff. If the parties cannot otherwise agree, they'll do it on Monday and Thursday, unless they can agree upon different days. And if they hopefully that would be a minimum, and that he would be allowed additional parenting time, but I don't know what the party schedules are either. So that will be the order. Ms. Capture, you can prepare that and submit under a 7-day notice of entry.
Thank you, Your Honor.
Thank you. Free to go. Have a good day. Court will note the appearance of Mr. Umloff on behalf of the plaintiff, Mr. Kelly on behalf of the defendant. The defendant has filed 2 motions, a motion to set aside the referee order in this matter, as well as an addendum to the motion to set aside. Mr. Kelly.
Your Honor, we filed the addendum after we actually received the transcript, so we could cite the actual errors in support of our motion. In a nutshell, Your Honor, my client is requesting not a change of custody, but an increase in his parenting time, as was made clear to the referee during that hearing. He was essentially looking to have his parenting time schedule changed to Friday to Tuesday, which plaintiff testified she actually wanted, and through her own attorney requested during closing argument that she wanted. My client simply wanted that expanded to Wednesday, so it was one more overnight that he was looking for. So we're not looking to change the established custodial environment. It's simply the lower burden of proof of preponderance of the evidence is allowed under Shade versus Wright, which should have been used, but instead of that, the burden of proof of clear and convincing evidence was used under the Vodvarka standard, which was error. Your Honor, I believe in reviewing the transcript, what was proffered to the referee was adequate for my client to get that one extra overnight, as well as summer parenting time and holiday parenting time, as the children are now of school age, and those are essentially standard parenting time that he would get. So we would be requesting of the court either, if it feels comfortable after reviewing the transcript, to grant that relief or set the matter for hearing to address those specific issues. And also in relation to the child support, Your Honor, I think we pointed out sufficiently that my client did testify. He worked and made 500 hours per week at a full-time job. Imputation is not appropriate under these circumstances when he is working a full-time job, as of course aware under the formula, because child support went from $0 because they had reserved it to over 1,100. They had him making 52,000 a year, which my clients never made. So I would request of the court, in regards to the child support issue, that the correct income figures be used and made retroactive to the date of the order. And if we could stay the current order, because that $1,100 a month is really killing him in relation to making his other bills. Thank you.
Mr. Kelly, I note I did have a chance to review the transcript, and I note that in answer to I guess the question as to what his income was by Mr. Umloff, he stated roughly $500 to $600 a week before taxes, and he said I would say closer to 500 in this particular matter. So where is the other amount coming from? Well, maybe Mr. Umloff can ask this. Where's the other amount coming from to make up the $50,000?
Your Honor, it's my understanding that amount is coming from a part-time job where he stopped working DoorDash and was working on a construction, making a lot more than he was on DoorDash. But again, that was just a temporary thing. And for whatever reason, I think they've combined those two incomes to come up with that $52,000 figure.
Okay. Mr. Umloff, what's your response?
Your Honor, a couple of clarifications. Firstly, as it relates to my client's testimony regarding the schedule that she wanted, if you look at page 31, paragraph 24 of the transcript, she indicates Friday to Tuesday, and we would submit Friday 6 p.m. to Tuesday at 6 p.m. on alternating weekends for the defendant. And that's what she indicated they were doing. Not every weekend, as I don't think opposing counsel stated that it was every other weekend. And we would be agreeable to making that the new schedule, Friday 6 p.m. to Tuesday at 6 p.m. on alternating weekends for the defendant, with that schedule being year-round with alternating holidays. So half of the school Christmas break, alternating spring breaks, but make this schedule permanent in the summertime as well.
Okay. Mr. Kelly, what's your response to that? I know you've asked for the Wednesday additionally, but
I think Your Honor, I think in the interim, if the matter is going to be set for hearing, my client wouldn't object to that schedule. Again, he's just looking for that extra overnight.
Okay. Go ahead, Mr. Umloff, as it relates to the rest of the motion.
As it relates to the rest of the motion, I would submit that the clear and convincing standard is the proper standard of review. But if the court is not agreeable to that, the evidence presented at the hearing does not establish by a preponderance of the evidence that the change in parenting time, the additional overnight is proper for the minor children. As it relates to the child support calculations, I noted in the income comments section on the child support calculations, there was a list of potential income factors for the defendant. It appears to me they imputed him income on the grounds that he was voluntarily unemployed. Those factors were listed out. So I do not believe that the proposed child support order is in error, but proper under his potential income.
Okay. Well, in this matter, the court will note that obviously the parties have at least a tentative agreement as it relates to the parenting time of Friday through Tuesday in alternating weeks. The court believes that that's appropriate in this matter, having reviewed the transcript. I do note that the referees put a lot of weight. He said that he had weighed the credibility in this matter and making a determination. I do have some issue and take issue with the support amount for the imputation when he is working full time. Court would order that the defendant would disclose at this point within 14 days that he would disclose any and all income earned this year to date, and provide that to Mr. Umloff within that 14 days. But the court at this point is going to not take the $50,000 that the referee did. The court would take the $500 that he acknowledged making each week, and then any other additional amounts that would be prorated over the year if he did work that construction job in this particular matter. So that will be the order of the court. I don't believe that the referee made any other errors in this matter after reviewing thoroughly reviewing the transcript. So that will be the order. I guess I'll ask Mr. Umloff, I'll ask that you would prepare that order and submit it under 7 day.
Thank you, Your Honor.
Okay, thank you.
Your Honor, one
Go ahead.
last question in relation to the child support calculation. When would that be made retroactive to?
We would, thank you for, we'd go back, we'd do that retroactive to the date of the referee's order.
Okay, thank you, Your Honor.
Thank you. Court will note the appearance of Ms. Huffman on behalf of the plaintiff. This matter is before the court on the plaintiff's motion for temporary custody parenting time support. Ms. Huffman.
Thank you, Your Honor. We did file that temporary or motion for temporary orders regarding the minor child. The parties do have one minor child. It is my understanding that the father in this case has not seen the minor child since April 1st, I do believe. He has made one call to speak with him, and then I believe just one text since then, asking what size clothes he wears, and that was just last week. Having had no contact with the child other than the one 5-minute or less phone call, I would ask that the court will suspend his parenting time completely at this time. I think until we can determine whether the dad is going to be in this child's life, it would just be better to continue his routine that he's had for the most of this year. We're asking for that, and then for child support in this case. I don't know where we don't know where he's working currently or how much he's making, so we'd ask the court if we could find that out or get a pay stub or something. And that's it until we can be heard otherwise. Thank you.
Okay, thank you. Mr. Stoner, what's your response? You'll have to unmute.
I have no problem paying child support. I would like parenting time. Ms. Stoner hasn't allowed me to see my child, so I've made numerous amounts of attempts to reach out to her, but a lot of times I don't get a response. I have talked to the child correctly one time, that's right, and I did send her a text last week to inquire about how my child was doing, and I inquired last Friday on what size clothes and shoes he wear, but she didn't respond.
Okay.
I am working. Full time, so I have no problem giving over my information.
Okay. What the court's going to do on a temporary basis is the court's going to maintain the status quo. The court will order that the plaintiff has the custody of the minor child. Support would be pursuant to the Michigan Child Support Formula and the guidelines that the defendant would provide to Ms. Huffman his most recent paycheck stub within 10 days of today's date. The court will grant to the defendant supervised parenting time. We'll do that no less than twice per week for up to 2 hours. And the court would order that the plaintiff would provide the defendant with the name of 3 supervisors who could supervise that parenting time. And then the defendant can pick which of those 3 supervisors he wishes to have to supervise the parenting time. And Ms. Huffman, that you would provide those names to the defendant within 7 days of today's date. Okay. Ms. Huffman, I'll let you prepare the order and submit under a 7-day notice of entry.
I will do that. I just have one other thing. I do believe it's my understanding that Mr. Stoner lives on the other side of the state. So I would ask that parenting time take place here in Calhoun County.
Okay, Mr. Stoner, you have any problem with that? It might be difficult to get any supervisors that would travel any distance.
I mean, it sounds like I don't really have too much of a choice, sir.
You don't have someone that would what?
I don't have too much of a choice.
Yeah.
If I got to do it in Calhoun County, then I have to do it in Calhoun County.
Okay. The court will say that the parenting time would occur in Calhoun County, and that would be based upon really the supervisor and whoever that might be that is supervising. Okay, Ms. Huffman, you can prepare the order and submit it under 7 days.
Well, I will do that. Thank you, Your Honor. Have a good day.
Thank you. You're free to go. Have a good day.
Cronkite versus Taylor Morgan. Today is Monday, September 9th, 2024 at 9:43 a.m.
Court will note the appearance of Ms. Reed on behalf of plaintiff and Mr. Bartell on behalf of the defendants in this matter. The matter is before the court on the Ms. Reed's motion to withdraw. Ms. Reed.
Thank you, Your Honor. We are requesting withdrawal from this matter. There's been a breakdown of the attorney and client relationship, and my client has failed to meet his financial obligations to the firm.
Okay. Mr. Conkright, you have any response?
I've spent over $15,000 trying to pay for lawyers, and with the other lawyer that I had, Paula, that I had represent me in the appeal. I literally have no more money. I've spent all my money trying to do the best I can for my daughter and keep her away from people she doesn't want to be around. And yeah, I've done the best of my ability to be the best father, but yeah.
Okay. Mr. Bartell, I don't assume you'll have any opposition to Ms. Reed withdrawing.
No, I don't have any opposition. My only note is, Your Honor, there's an outstanding order regarding the counselor that I have not received from the other side. Mr. Umlauf had appeared and I've had no communication. I had sent him an email and there's been no response as to selecting the counselor. So I just note that, Your Honor. And then the second part is I'm just asking that there be no further adjournments of the hearings.
Well,
because there's been several adjournments.
Yeah. We don't want to adjourn the matter, so I will grant Ms. Reed's motion to withdraw, and we will proceed as scheduled in this matter. Okay, you're free to go. Have a good day.